Your Honor.
For his hopefully brief reply. Yes, Attorney po.
Just before we give Attorney Ligutan his time, Your Honor, just wanted to make a quick manifestation. It was just brought to our attention yesterday that after the proceedings that we had yesterday, that an interview was given wherein I think what was discussed yesterday about the word scam, etc., was repeated during an interview. Now, while it may have been stated in a matter that's sort of a matter of factly, we do hope that this will be included in the ruling of the Honorable Presiding Officer.
It
At
is
least for
included
guidance, Your
actually,
Honor.
Attorney po.
Thank you, Your Honor.
Yes, Attorney Ligutan.
Hello. It's working. Hello.
You are recognized, sir. You may proceed when you're ready with respect
so
to
much.
your, shall
It's
I
brief.
call it, counter manifestation.
It is brief, Your Honor.
Thank you, Attorney Ligutan. You may proceed.
A teacher, a lawyer, a rule on cross-examination, a Facebook post. How did we get here? Last August 12, before trial was adjourned, it was a Wednesday. Out of the blue, the defense made a manifestation, or should I say, a big issue of my Facebook post earlier that morning. My post reads, a principle all lawyers and law students know by heart. Misleading questions are not allowed, even on cross-examination. Period. The defense surmised it is a reaction to that viral exchange between the opposing counsel that morning. A lawyer for the defense said, in effect, that misleading questions are allowed. We all heard it. It immediately caused an uproar on social media, especially in the legal community, where it is a well-entrenched rule that misleading questions are not allowed, even on cross-examination. It is a truism as irrefutable as the sun rising in the east and setting in the west. It is a principle all lawyers and law students should know by heart. But why post it on Facebook? Your Honors, why not? Yes, I am a lawyer. But more than just a lawyer, first and foremost, I am a teacher. Isa po akong guro. Usa ko kang maestro. And I'm proud to be one. I have been a lawyer for almost 16 years, but I have been a teacher, an educator for almost 20. At alam ng ating mga magigiting na guro sa buong kapuluan na ang pagtuturo ay likas sa ating mga guro. Ang pagtuturo, ang pagtatama ng mali, ay walang pinipiling lugar at walang pinipiling panahon. That's why I made that post. I was concerned that the statement made in open court that misleading questions are allowed will go unchecked. My teacher's instinct kicked in. I wanted the students I left in Cebu, especially in the University of San Jose Recoleto School of Law, where I have been teaching for the past 15 years, and recently in the University of Cebu School of Law, and in Diliman, my alma mater, the University of the Philippines College of Law, and all law students out there. I want them to know that a teacher had heard that wrong statement in open court, and he is correcting that mistake on Facebook as I have been doing the past years. To the defense, I shall not name names. I will not put you on the spot. But the post is not about you. It's not personal. It is about the law that we all adhere to. It is about what we teach the public who are watching our trial. Correcting a mistake is never wrong. Doing it while a hearing is ongoing online does not make it not right. Ang pagtatama ng mali ay kailanman hindi ipinagbabawal kahit sa loob ng impeachment court ito. Now the defense said they found it troubling or in bad taste for a prosecution lawyer like me to, quote, do this, unquote, in the middle of a courtroom hearing. But do what? Correct a wrong? On the contrary, Your Honors, what is more troubling is for the defense not to admit their mistake and instead call out a lawyer, a teacher, who just stated what is correct in his own time and in his own Facebook account. What is troubling is if we turn a correction of a mistake by one side into a shield from fair criticism for the other. Now the defense is asking this court to act on my post. It is elevating it to a serious courtroom violation. But what did I violate? I did not discuss the merits of the case. I did not discuss the strength or the weakness of the oral arguments or evidence of either side. I only stated, without mentioning any name, using the most neutral of font color and background, black and gray, without adding any emoticon, without splicing anything. What the rules of procedure simply provide, that misleading questions are not allowed, even on cross-examination. Your Honors, we in the prosecution also have rights. I, for one, did not surrender my freedom to teach and to enlighten when I decided to participate in this trial. Patuloy po ako magiging guro kahit sa loob ng impeachment court na ito. Lastly, Your Honors, the defense mentioned humility. That I should have been humble enough not to post that now viral statement. Your Honors, being a provinciano from Leyte, Samar, and Cebu, and coming from a middle-income family born without a famous family name, who had to compete for his spot in this capital, I know a thing or two about humility. The defense cannot lecture me on humility. If there's somebody who needs to be reminded about humility, it's them, the defense. It is the opposite of humility. It is pride, not to admit a mistake, or worse, call out someone who simply corrected that mistake. Good morning.
That does not fall under my definition of brief, counsel, but we will take it nevertheless. For For the record, before the chair makes its ruling on these matters, the TSN says, Attorney Kapunan, leading, and then she corrected herself, misleading questions are not allowed on cross. Attorney Ferrer, she said they are allowed. Now, the TSN cannot possibly cover the overlapping voices, if at all. So most likely what happened, although we will check the video, would be Attorney Ferrer commenting on the earlier statement that was corrected later on by Attorney Kapunan and changed leading to misleading. Perhaps Attorney Ferrer was referring to leading questions and not misleading questions. But having said that, nevertheless, the court will include that as part of its ruling, with one caveat, Attorney Ligutan. While you do not remove your hat as a teacher wherever you go, the same is true with this representation. I had my fair share of teaching as well. Under the rules of the Senate, unfortunately, you have to unbundle it. You have to decouple it. Under the rules of the Senate, if you are counsel for the parties, you cannot comment on the merits outside of a fair and true report of what happened. In this case, based on the TSN, I am not sure of the accuracy, given that the statements made were pertain to both leading and misleading questions. Number two, it still does not take away, your being a teacher, does not take away your responsibility under the CIPRA to a fellow lawyer who you are jousting with or arguing with or competing against this impeachment court. The remarks of the good gentleman, the Attorney Ligutan, the counsel for the panel of prosecutors, is noted and it will be entered into records. Thank you, sir. Chair will now make its ruling with the permission of the body from the rostrum, because it's difficult to read while sitting down a long ruling. You may sit down, Attorney Chua, for a bit. This will take some time. With the permission of the senator judges. The chair wishes to address certain matters as it is necessary to protect the integrity of this trial. It has come to the chair's attention over time that public statements attributed to persons covered by the rules on impeachment, whether made in interviews or in social media, appear to concern the evidence, the credibility of witnesses, and issues pending before this court, which may fall within the prohibition under Rule 18 of this court. Although the immediate matter arose from statements and conduct involving respective counsel last August 12, it raises broader concerns affecting the impartiality, decorum, and integrity of the impeachment court. Before imposing or enforcing standards of restraint upon the parties and their own counsel, the court must first look inward and put its own house in order. The chair shall therefore resolve these matters in three parts. First, the duties of impartiality and decorum incumbent upon senator judges. Second, the scope, coverage, and prospective enforcement of Rule 18. Third, the specific guidelines governing compliance with Rule 18. First, senator judges' impartiality, decorum, and the internal remedy. The chair begins where institutional discipline must always begin, with the court itself. The restraint, impartiality, and decorum demanded of the parties and their counsel must first be exemplified by those who sit in judgment. As senator judges, let us keep in mind our oath, quote, to do impartial justice according to the Constitution and the laws of the Philippines, close quotations. And the requirement under Rule 3 of the Rules of Impeachment to observe political neutrality therein defined as, quote, the exercise of a public's official duty without unfair discrimination and regardless of party affiliation or preference. The chair likewise cites the relevant provisions of the 2025 Code of Judicial Conduct and Accountability, or CIPRA, on impartiality and the sub judice rule. Canon 3, Section 10 provides, quote, during the pendency of a case, a judge shall not knowingly make any comment in and out of court that could reasonably be expected or perceived to affect its outcome, impair the fairness of the process, or diminish the public's confidence in the court's impartiality. Canon 4, Section 24 provides, quote, "A judge shall not engage or use any form of expression which tends to violate or has the effect of violating the sub judice principle, provoke or inflame divisive and contentious issues of public concern, or project an image not compatible with the dignity of their position." Taken as a whole, these principles remind us of our duty to preserve the impartiality of this court and the fairness of these proceedings. As the court said in People v. Court of Appeals, GR number 118882, this court has repeatedly and consistently demanded, quote, "the cold neutrality of an impartial judge as the indispensable imperative of due process. Judicial proceedings are not orchestrated plays in which the parties are supposed to make motions and reach the denouncement according to a prepared script. There is no writer to foreordain the ending." Close quotation. Also in Berso versus Rabe, AM number RT 21010, a judge must not only be impartial, but must also appear to be impartial, as an added assurance to the parties that his decision will be just. Litigants are entitled to no less than that. For avoidance of doubt, this shall not prevent senator judges from examining the evidence where the examination belongs during the proceedings and on the record. The Supreme Court in People v. Gambor, GR 152183, said, "The trial judge is accorded a reasonable leeway in putting such questions to witnesses as may be essential to elicit relevant facts, to make the record speak the truth. A judge may examine or cross-examine a witness. He may propound questions to test the credibility of the witness and to extract the truth. He may seek to draw out relevant and material testimony, though that testimony may tend to support or rebut the position taken by one or the other party. It cannot be taken against him if the clarificatory questions he propounds happen to reveal certain truths which tend to destroy the theory of one party." Taken together, Rule 17 and the Gambor case confirm that a searching question is not partial merely because the answer may aid one side or weaken the other. The prosecution and the respondent's counsel must be prepared to answer such questions. The inquiry must remain relevant, material, fair, and directed toward clarification of truth. It must not devolve into a speech, harassment, partisan advocacy, or an announcement of a conclusion already reached. The line is clear. Senator judges may test the evidence here under oath and on the record, exercising the cold neutrality of an impartial judge. When constituted as an impeachment court, the Senate does not cast aside the discipline of parliamentary practice, except where the specific rules on impeachment or the adjudicative nature of these proceedings require otherwise. The rules of the Senate establish parliamentary precedents and courtesies of the chamber continue to bind every member sitting as senator judge under Rule 34, Sections 93 and 94 of the Rules of the Senate. Deem acts or language that offend a senator or any public institution or third party to be unparliamentary and prohibit the use of offensive and improper language against another senator or public institution or third party. Henceforth, I hope senator judges shall refrain from unparliamentary remarks, personal attacks, imputations of improper motive, and other language incompatible with the dignity of these proceedings and of parliamentary courtesy to other people. The chair will at all times extend to his fellow senator judges the courtesy befitting equals and reasonable latitude that serious deliberation requires. Differences in judgments and vigor in debate are to be expected and shall, as far as practicable, be met with patience, flexibility, and respect. Should circumstance so require, however, the chair will not hesitate to enforce the rules of this impeachment court, the rules of the Senate, particularly sections 95 and 96. In this chamber, firmness need not be unkind, nor courtesy come at the expense of duty. Both serve the same end, the fair and honorable administration of justice. Further, where a senator judge is alleged to have violated the impeachment oath, Rule 3, Rule 18, or any other applicable rule of the Senate. An available institutional remedy within the Senate is the filing or referral of an ethics complaint to the Senate Committee on Ethics and Privileges in accordance with the internal rules of the Senate. Under Rule 10, Section 1316 of the Rules of the Senate, the Committee on Ethics has jurisdiction over all matters relating to the conduct, rights, privileges, safety, dignity, integrity, and reputation of the Senate and its members. Any disciplinary action remains for the Senate to determine under Article 6, Section 16.3 of the Constitution and applicable rules. This shall not be a proper subject matter to be taken up within this impeachment court so as not to divert the attention from the impeachment trial against the respondent in this case. Accordingly, the chair reminds all senator judges, first, to observe the impartiality and political neutrality required by their oath and the rules. Second, to observe the parliamentary rules, precedents, and courtesies of the Senate and refrain from unparliamentary, offensive, or improper remarks. Third, to exercise their authority under Rule 17 to question witnesses, prosecutors, and counsels for the respondent and the prosecutor during the proceedings on the record instead of through commentaries in social media. Second ruling, Rule 18, scope, coverage, and prospective enforcement. Note on the statement, prospective enforcement. Having addressed the conduct expected of senator judges, the chair now turns to Rule 18 and the persons expressly covered by it. The chair makes this ruling not only in response to the manifestation and motion made by counsel for the respondent, Attorney Sheila Season, on August 12, and after due consideration of Attorney Ligutan's explanation, but also on the basis of the chair's independent findings of seeming violations of Rule 18. These incidents come after the chair's earlier advice to both panels to designate the respective spokespersons so that the necessary and appropriate communications may be made within the limits prescribed by the rules. Since that advice has not been fully observed, the chair now finds it necessary to restate and strictly enforce those restrictions. Article 18 of the Rules on Impeachment provides, the presiding officer, the members of the Senate, shall refrain from making any comments and disclosures in public pertaining to the merits of a pending impeachment trial. The same shall likewise apply to the prosecutors, the person impeached, and their respective counsel and witnesses. This rule exists to balance the public's right to information on matters of public concern with the need to protect the integrity of the proceedings from public prejudgment. The rules of court apply only suppletorily to these proceedings. When the rules on impeachment expressly and specifically govern a matter, they control. Since Rule 18 directly governs public comments and disclosures pertaining to the merits of the pending impeachment trial, it is for this court, in the exercise of its authority and sound discretion, to determine whether a particular statement violates that rule. Henceforth, with respect to prior statements or conduct covered by Rule 18, the court shall extend grace, exercise liberality, and wipe the slate clean, tabula rasa, so to speak. From this point forward, however, Rule 18 shall be strictly enforced and be given full force and effect. Accordingly, the chair hereby strictly enjoins all persons covered by Rule 18. You know who you are, and based on the records, we know who you are. From making public statements or otherwise discussing, sharing, or endorsing comments pertaining to the merits of this pending impeachment trial, and from engaging in trial by publicity, as they directly threaten the independence of the court, degrade the dignity of the tribunal, and risk turning it into a circus, and weaponize the media to substitute public outrage or actual evidence. We are in receipt of the appearances of the parties. So, ang covered po ng Rule 18 would be all those who appeared, both from the panel of prosecutors and the counsel for the panel of prosecutors. Chair earlier reminded the parties, designate a specific spokesperson. Wala pong problema kung hindi naman siya kasama sa panel. Walang problema kung hindi siya kasama sa counsel for the panel of prosecutors. The spokespersons are free to say whatever they want to say, but not, and there are limitations insofar as the panel of prosecutors and the counsel for the panel of prosecutors is concerned. Clearly, up to today, the spokesperson of both parties are still part of the counsel for the parties. some with more violations than others. So without enumerating the councils where this rule applies, I think you know who you are, given the entries of appearance you've already made. These restrictions apply with particular force not only to counsel for the parties, but also to us, senator judges, and all other persons whose public statements are governed by Rule 18. Rule 18 makes specific mention of the respondent. It does not make mention of the complainants in this case, given the public nature of this case. So outside of the senator judges, outside of the counsels for the parties, particularly mentioned would be the respondent herself, as well as the witnesses called. Third ruling, guidelines for compliance with Rule 18. To ensure a common standard, the chair now states the guidelines governing compliance with Rule 18. That line is crossed when a public comment by any person covered by Rule 18 falls within the phrase, quote, pertaining to the merits. In this regard, jurisprudence has consistently distinguished matters going into the merits of a case from those which are merely procedural, incidental, or collateral. In De Leon versus Deliana, GR 21-2277, as a technical legal term, merits has been defined in law dictionaries as a matter of substance in law as distinguished from matter of form, and as the real or substantial grounds of action or defense, in contradistinction to some technical or collateral matter raised in the course of a suit. In Badoy versus Magdoza Malagar, AM number 220916 SC, comments on the merits of the case may refer to the credibility of witnesses, the character of the accused, the soundness of alibis offered, the relevance of the evidence presented, and generally any other comment bearing on the guilt or innocence of the accused. Pursuant to the en banc case of INRE published threats hurled by Attorney De Vera, AM number 011203 SC, number 1, no party shall make public comments, statements, insinuations, or rhetorical questions that, number 1, prejudge the issue to predict the outcome of the trial. Number 2, question pending rulings. Number 3, substitute media pressure for evidence. Number 4, promote distrust and undermine public confidence in the court by creating the impression that the court cannot be trusted to resolve the case impartially and violate the right of the parties to have their case tried fairly by an independent tribunal uninfluenced by public clamor and other extraneous influences. For purposes of this trial, a statement pertains to the merits when viewed in the full context. It evaluates in its full context. It evaluates a disputed fact, the credibility of a witness, the relevance or probative value, weight or sufficiency of a particular evidence, assessment as to the legal viability of an article of impeachment, or a substantive defense advocates a particular disposition of the charges or announces or forecasts the ultimate vote. Conversely, this court recognizes the qualified privilege of a fair and true report regarding these proceedings as affirmed in the Supreme Court in ABS-CBN versus Ampatuan GR number 227004. Based on the jurisprudential standard derived from Article 35 of the Revised Penal Code, a fair and true report means a neutral, objective, and accurate recounting of the proceedings made in good faith without any comments or remarks. For the guidance of all the parties concerned, the chair now issues the procedural guidelines for violations of Rule 18. The impeachment court will exercise its powers summarily under Rule 5, adhering strictly to the due process parameters set by the Supreme Court. First, a 24-hour show cause order. No oral accusation or press pronouncement shall precede the formal charge. Any party cited for a particular violation will be issued a written show cause order, either motu proprio or upon motion by either party, and will be given exactly 24 hours to submit a verified written answer. Pursuant to the Supreme Court's en banc doctrine in Zaldivar versus Sandigan Bayan, GR number 79690-707, due process in disciplinary proceedings against lawyers and parties does not require a trial-type formal hearing. The presiding officer will rule summarily based solely on the submitted pleadings upon the lapse of the 24-hour period, subject to appeal or reconsideration by any member of the court. Now, the burden of proof pursuant to Stratcom Corp versus Etong, GR number 190980, and Webb versus Gatula, GR number 194469, any punitive sanction requires this court to find that, quote, a person's act must be done willfully or for an illegitimate or improper purpose. Thus, the good faith or lack thereof of the person being cited in contempt should be considered. Hence, the contemnor is presumed innocent, and the burden of proving that the contemnor is guilty of contempt lies with the movant. For violations of Rule 18, the court shall follow a two-strike rule. Violations will be met with a strict graduated penalty system. First offense, public reprimand and admonition. The penalty is a severe reprimand and stern admonition in open court, placed permanently on the record as a final warning. Second offense, a monetary fine. The penalty, pursuant to the prescribed ceiling under Rule 71, Section 7 of the court will impose a maximum statutory fine of 30,000 per violation. Pesos, that is. Furthermore, exercising the court's inherent case management powers under Rule 4, 5, 6, and 8 to preserve the orderly proceedings, the offending lawyer or party may also be subjected to a defined prospective restriction on speaking, objecting, or examining witnesses on the floor. Each subsequent violation of Rule 18 shall be punished the same way as a second offense, third, fourth, so on, with a fine of 30,000 pesos. In all cases wherein a member of the bar is concerned, independently, pursuant to the case of Inre Almacen, the certified incident record will be transmitted and formal referral will be made to the office of the bar confidant, the Integrated Bar of the Philippines, and or the Supreme Court for possible disciplinary sanction regarding the person's license to practice. The court also reminds respective counsels of the parties that CIPRA Canon 2, Section 19 prohibits lawyers to comment or publicize opinion pertaining to a pending proceeding in a manner that may cause prejudgment, sway public perception, influence the tribunal, or create a widespread perception of guilt or innocence. CIPRA likewise requires professional responsibility on the use of social media and prohibits the dissemination of false or unverified claims or disinformation. Rule 18 does not, by its terms, cover outside observers or spokespersons who are not counsels of record. Such persons, however, remain subject, when applicable, to the rules on indirect contempt, and if they are members of the bar, to the CIPRA. Counsel of record must litigate their respective causes before the court, not in the court of public opinion, through interviews, social media posts, or publicly generated, authorized, encouraged, or disseminated through surrogates. Counsel cannot have their cake and eat it too. They cannot invoke the authority of this court while simultaneously seeking to influence the proceedings through extrajudicial publicity. In fact, the chair has in its hands certain statements to cite as examples, without naming names, but you know who you are, who mentioned these quotes. Quote, hindi naman pinag-uusapan dito yung kontrata, pinag-uusapan dito yung banta. Yung banta, nakita nyo sa video, may nagbanta talaga at si Vice President yon, hindi ba? If this was stated by a spokesperson or any third-party observer, it would not have been a problem. But this was stated by a counsel of record. Actually, more specifically, one of the counsels for the private prosecutors. Quote, the country witnessed what I have been saying all along. The complaint is not supported by evidence. An impeachment proceeding should be grounded on credible evidence, not speculation, manufactured narratives, or unsupported allegations. The rule of law depends on facts, not fiction. Quote, meron ba talagang kinausap na mamamatay tao? Meron ba talagang mamamatay tao? Napakaliwanag na ho sa sagot dyan. Meron. Ano ho ang prueba natin? Yung tinatawag na admission against interest ng Vice President. Again, to reiterate, if this was stated by any other party or person, not a member of the panel of prosecutors, not counsel for prosecutors, not the counsel for respondents, it would have been perfectly okay. But since this was stated by one of those covered by Rule 18, it is covered by Rule 18. Quote, since na-establish na namin yung hinahanap namin doon sa talagang testigo lamang, 3 testigo lamang, finorgo na namin yung ibang mga testigo, na-establish na namin ang gusto namin establish sa Article 4. Quote, itong mga bank records don't lie. Hindi na ito pwedeng maspin. Yan at sabihin gawa-gawa lang ng prosecution ng gobyerno. Itong mga usapin na ang explained wealth ng Vice President. Quote, it is clear that the Vice President had a direct hand on this. She signed off to it. No, not just the use, but the way it was liquidated. Quote, yun pong binabanggit ni Atty. Capona na scam. Yun pa rin ho yun. Pagtingin ho namin na inilantad ngayong araw po na ito, yung pagiging scam, iskandalo nitong confidential fund misuse. Quote, malinaw din na sinasabi niya na hindi kailangan sabihin pa na ginamit ito para sa personal na paggamit ng Vice President, itong confidential funds na ito. Dahil sabi nga niya, nakalagay na yan doon sa joint circular. Quote, siguro naman, it's plain for everybody to see yung conclusion, no? Yung conclusion na tama ba yung pinagamitan ng confidential fund? Hanggang kailan ba yung pagpipikit mata natin sa isang bagay na napakaklaro naman? Quote, to be fair, let's wait for their defense if they have any or their evidence. But so far as we are concerned, our position, you violated the public trust. Fraudulent liquidation, so you have violated the law. You already betrayed the people's trust. Quote, sa totoo lang po, yung testimonya ni Ms. Acosta na nagsasabing si Pangalawang Pangulo Duterte mismo ang nagbigay ng utos na ibigay ang 125 kay Colonel Lachica. Sapat na ho yun doon sa pagpapakita ng maling paggamit ng confidential fund. Quote, to us, it's a scam that was masterminded by the Vice President. Again, these are statements that may be said by any third party, but certainly not by any of the counsel for the parties. I would like to give credit where credit is due as well. There are some counsel for the parties who have been very circumspect with their statements. And you also know who you are. After hearing these examples, no person covered by Rule 18 may reasonably claim uncertainty as to where the line is drawn. The statements read into the record are illustrative, not exhaustive. They are cited not to punish past conduct, but to give clear and fair warning of the standard that shall govern henceforth. As the Chair stated in my opening statement, the discretion entrusted to this court will be exercised with a steady hand, liberal where justice permits, but exacting where fairness, due process, and the integrity of these proceedings demand. Consistent with that commitment, the court will strictly enforce the restraint required of counsel outside the courtroom, while ensuring that within the courtroom, counsel are afforded reasonable latitude to present their arguments, challenge rulings through proper channels, and advocate their respective causes fully and fairly. This discretion does not require counsel to remain silent within the impeachment court. The Supreme Court ruled in ABS-CBN Corporation versus Ampatuan, as earlier cited, that the court recognizes that lawyers may criticize the courts and their decisions, subject to the responsibilities they bear as officers of the court. Such criticism, however, must be legitimate, made in good faith, and directed toward the proper administration of justice. Rule 18 closes the avenue of litigating the merits through interviews, social media, and the court of public opinion. It does not close the courtroom to legitimate advocacy. If counsel believes that the ruling is erroneous, that a proceeding has become unfair, or that conduct affecting the trial requires correction, the proper course is to bring the matter before the court where it may be heard, answered, and resolved on the record. Rule 18 demands restraint beyond these walls. It does not command silence within them. This court will not close the door to trial by publicity. Rather, this court will close the door to trial by publicity, but it will keep the courtroom open to the disciplined advocacy where evidence is tested, error is corrected, and justice is done. Within these chambers, counsel shall be afforded reasonable latitude to present their theory of the case and vigorously test the evidence. Emotions may run high and frustrations may arise in the course of adversarial proceedings, but neither excuses a departure from the restraint and decorum expected of officers of the court. The case of Navarrete versus Court of Appeals, GR number 124245, mirrors the exact situation that has transpired before the court. Quote, with respect to the words swindlers, plunderers, stupid, and bastards, uttered by private respondent in the course of her testimony, we are inclined to disagree that such language is too ignominious and degrading for a lawyer to say to a fellow lawyer in the courtroom. In Baltao versus Falsis III, AC number 14443, the court said, while a lawyer is entitled to present his case with vigor and courage, such enthusiasm does not justify the use of offensive, abusive language. Language abounds with countless possibilities for one to be emphatic but respectful, convincing but not derogatory, illuminating but not offensive. The latitude afforded to counsel is not a license to substitute inflammatory, intemperate, or undignified characterizations for proof. Consistent with the chair's earlier ruling, the term scam, mastermind, modus operandi, as used during the past proceedings, stands stricken from the record. Counsel remain free to advance the factual and legal theories underlying their positions, but they must do so through evidence, reasoned argument, and court-appropriate language, not through expressions that prejudge disputed facts, attribute wrongdoing not yet established, cast offensive personalities upon others, or needlessly inflame the proceedings. Language uttered in the presence of the court that amounts to disrespect, offensive personalities, or misbehavior that obstructs or interrupts the proceedings may, when the applicable threshold is met, be dealt with as direct contempt under the rules on impeachment, with Rule 71, Section 1 of the rules applying suppletorily. Whether or not such language rises to the level of direct contempt, counsel remain independently bound by the CIPRA to observe courtesy and civility and the use of dignified language in all their professional dealings, even as adversaries. This brings the chair to the relevant provisions of the CIPRA independently of Rule 18, Canon 2 of the CIPRA requires every lawyer at all times to observe respect and courtesy in personal and professional dealings. Canon 2, Section 2 further requires lawyers to act with courtesy, civility, fairness, and candor towards fellow members of the bar. These duties govern how counsel treat one another both in and outside the courtroom. Canon 2, Section 4 likewise requires dignified language in all personal and professional dealings and prohibits abusive, intemperate, offensive, or otherwise improper language, whether oral or written, and whether made through traditional, electronic, mass, or social media. For the avoidance of doubt, Rule 18 applies only to the persons expressly covered therein: the presiding officer, the senator judges, the prosecutors, the person impeached, and their respective counsel and witnesses. With respect to counsel, Rule 18 applies specifically to those who have formally entered their appearance before the impeachment court. Separately, when a spokesperson is a member of the bar but has not entered his or her appearance, the relevant provisions on indirect contempt under Rule 71, Revised Rules of Court, and when warranted, the CIPRA shall nonetheless apply to said person. In any case, this shall be without prejudice to any recourse to Rule 71, Revised Rules of Court, with respect to any person who may commit indirect contempt against the impeachment court not covered by Rule 18. Accordingly, the chair hereby declares, number 1, directing all persons covered by Rule 18 to refrain from making, sharing, endorsing, or otherwise amplifying any public statement concerning the merits of the pending trial. Counsel for both parties are further directed to observe the applicable provisions of CIPRA. Number 2, reiterates the chair's suggestion that each party consider appointing a spokesperson who is not a member of their legal team, or if they are, for it to be clear to them that these rules shall apply to them, given that they are counsel for the parties strictly. If the parties elect to retain their current spokespersons, the Rule 18 shall be strictly applied as to them. The court further advises respective counsel that the violation of this order may carry consequences separate from contempt. Where the same conduct appears to violate CIPRA, the chair may direct the clerk to transmit the certified copy of the pertinent order, transcript, and records to the Supreme Court or the Office of the Bar Confidant for whatever action the Supreme Court may deem proper. Such transmittal is a referral, not a finding or penalty of professional discipline. Disciplinary jurisdiction over members of the bar still remain with the Supreme Court. Further, for avoidance of, again, doubt, a referral through the Office of the Bar Confidant shall not rest on an alleged violation of Rule 18 standing alone. Such referral may concern other conduct outside of Rule 18 unbecoming of a member of the bar. The chair then issues this final warning: on any willful disobedience of this order, it shall be dealt with accordingly henceforth. The ruling prescribes the standards governing future conduct and does not by itself adjudge any identified person guilty of contempt or liable for a professional violation. The chair closes with separate reminders to the prosecution, counsel for the respondent, and senator judges. To the prosecution, the primary duty of a public prosecutor is not to convict, but to see to it that justice is done. This duty is expressly stated in Canon 2, Section 31 of CIPRA, and echoed in Attorney Francisco versus Attorney Zuniga Lagman, AC 13035. The prosecution's object must therefore be the just resolution of the case, not victory at all costs. This obligation governs not only the evidence and arguments presented before the court, but also counsel's conduct outside of it. To the respondent and her counsel, the corresponding duty of defense counsel is not to secure an acquittal at all costs. In People of the Philippines versus XXX, GR number 245926, the Supreme Court reminded counsel for the accused of their fiduciary duty to provide competent, efficient, consensuous, and diligent representation. Under the same reason, counsel for respondent must faithfully protect their client's constitutional and procedural rights, rigorously test the prosecution's evidence, and hold the prosecution to the burden of proof governing these proceedings, while remaining within the bounds of the law, ethics, and the lawful orders of this court. To my fellow senator judges, including this representation, the chair adopts the reminder in Webb versus De Leon, GR numbers 1234 and 1245. Quote, more than convicting the guilty and acquitting the innocent, the business of this court is to assure fulfillment of the promise that justice shall be done and is done, and that the only way for this court to obtain an acquittal, from the bar of public opinion. That obligation rests upon every senator judge to decide solely upon the record, under the Constitution and under our rules, and in a manner worthy of the confidence of the people to whom this court is ultimately accountable. Thank you, and we may proceed with the trial at hand. Sorry, ma'am.
Your Honor.
Before recognizing the Honorable Chua, Chair would like to instruct the Clerk of Court through the OSA to kindly situate Mr. Ortonio to the witness stand. Yes, Honorable Chua.
Your Honor, may I now turn over to the counsel for the prosecution.